In this video, we will walk through how Danish companies can navigate key legal procedures using MitID in a way that is secure, compliant, and operationally efficient. The goal is to translate what can feel like a complex digital identity framework into a practical toolkit you can apply in your day-to-day operations. We will focus on the core use cases most relevant for companies: establishing and managing digital authority, signing legally binding documents, interacting with public authorities, and ensuring internal governance and control. To start, it is essential to understand what MitID is in a corporate context. MitID is Denmark's national digital ID solution, and for companies it functions as the backbone for identifying individuals in a secure and standardized way when they act on behalf of a legal entity. While MitID was initially designed around individuals, the ecosystem now includes specific solutions for business use through MitID Erhverv and integrations to key platforms such as Work.dk and Digital Post. The crucial concept is who can do what on behalf of whom. Your governance of that question determines your legal risk profile. Practically, the first step for any Danish company is to ensure that the company's data is correctly registered in the Central Business Register, CVR, and that the right individuals are formally authorized as signatories or representatives. This is not just an administrative detail. MitID-based flows often rely on CVR data and associated roles to validate whether a person can act on the company's behalf. For example, when creating a MitID business profile, granting rights to employees, or signing binding agreements electronically. If your CVR data is outdated or incomplete, you will see friction and, in some cases, a hard stop in digital procedures. Once your CVR foundation is in place, the next step is to set up and structure your use of MitID Erhverv. In practice, this means designating one or more administrators who will be responsible for managing access and rights. These administrators should have a clear mandate from management, be trained in both the legal implications and the technical steps, and work from a formal access management policy. A common best practice is to define roles that mirror your internal controls. For example, a procurement role, a HR role, and a finance role, each with specific rights for signing contracts, accessing digital post, or submitting reports to authorities. This role-based approach reduces the risk that a single employee will have overly broad powers and makes it easier to maintain compliance when staff roles change. When it comes to signing legally binding documents, MitID plays a central role in ensuring that the identity of the signer is verified and that the signature can be relied upon in a legal dispute. Many contract platforms and public portals in Denmark support MitID-based signatures, and these are widely recognized as equivalent to handwritten signatures in most contexts, particularly where parties have agreed to electronic signing. For companies, the challenge is not so much the technology itself as the internal discipline around who is allowed to sign what. Management should define clear signing rules that align three layers: your articles of association and registered signatory powers in CVR, your internal delegation policies, and your configuration of rights in systems that use MitID. For example, if two signatures are required for contracts above a certain value, your digital signing workflows should reflect that, and access to sign via MitID should be granted accordingly. From a legal risk perspective, it is critical that you regularly review logs and access rights. MitID-based systems will typically provide audit trails showing who signed what and when. These logs are valuable not just for dispute resolution, but also for internal control. Leading companies incorporate periodic reviews of digital signing logs, comparing them to their approval matrices and documenting any exceptions. In the context of public authorities, MitID is the key to efficient, secure interaction with the Danish public sector. Many mandatory procedures, including submissions to authorities, applications for permits, and access to digital post, depend on the correct setup of MitID rights. Companies should ensure that individuals with legal or compliance responsibilities have the necessary access to relevant portals, and that this access is not concentrated in one person, creating single points of failure. For example, at least 2 people should be able to access digital post for the company to avoid missed deadlines during holidays or staff turnover. One area that deserves particular attention is onboarding and offboarding employees who use MitID on behalf of the company. When a new employee joins, there should be a documented process defining which MitID related rights they need, who approves those rights, and how they are granted. Equally important, when someone leaves the organisation or changes role, their rights should be reviewed immediately and, if necessary, revoked or adjusted. This is not merely good practice. From a legal standpoint, former employees retaining access can expose the company to unauthorised commitments or breaches of confidentiality. Integrating these steps into your HR and IT offboarding checklists reduces the risk of oversights. Data protection and confidentiality also intersect with MitID-based procedures. While MitID itself is highly secure, companies must ensure that they do not undermine that security through weak internal practices. This includes training employees to never share MitID credentials, to carefully verify what they are signing, and to be alert to phishing attempts that imitate MitID flows. For sensitive legal procedures, such as signing high-value contracts or filing critical regulatory submissions, it can be prudent to require a 4 eyes principle. One person prepares and another reviews and confirms the action before it is signed. Over time, many companies find it valuable to formalise their MitID usage in a concise internal policy or guideline. This document should describe in clear terms how MitID is used in the company, which roles exist, who owns the process, how rights are granted and revoked, and how often controls are carried out. It does not need to be long, but it should be up to date, approved by management, and communicated to relevant staff. Having such a policy can also be advantageous in dialogues with auditors, banks, and other stakeholders who increasingly look at digital identity governance as part of their risk assessments. Looking forward, Danish companies can expect that reliance on digital identity solution like MitID will only increase, both in private contracts and in public sector interactions. This creates efficiency opportunities, including faster decision-making, fully digital workflows, and improved traceability. However, it also means that digital identity management becomes a core element of corporate governance, on par with financial controls and data protection. Companies that take a proactive, structured approach today will be better positioned to adapt to new requirements and to leverage digital tools in a secure way. To summarise, navigating legal procedures with MitID effectively comes down to 5 practical disciplines. Ensure your CVR and signatory data are correct. Set up MitID verb with clear roles and mandates. Align digital signing rights with your legal and internal approval rules. Manage onboarding, offboarding, and training with discipline. And embed these practices in a simple but robust internal policy with regular reviews. By doing this, Danish companies can move from seeing MitID as a technical hurdle to using it as a strategic enabler of secure, compliant, and efficient legal processes.